Hey everybody, welcome back to the Consumer Warrior Podcast. The podcast is dedicated to helping you with your big debt problems. If you're just dabbling in debt, this isn't the podcast for you. We deal with the big debt problems like repossession, debt collection lawsuits, foreclosure, bankruptcy, and all the other horrible things that can happen in the world of financial problems. We're really here to help you to help yourself. Welcome back to the show. I'm your host, John Skiba. And on today's episode, I want to talk about a problem that is so pervasive in debt collection world and simply abusing creditors that rarely a day goes by in my law practice where I don't meet someone who deals with that. And it is a default judgment, a judgment that just has come out of nowhere. All of a sudden your wages are getting garnished and you didn't even know you're involved in a lawsuit. I'm going to tell you one of the key things, the number one thing you have to look at to determine if you have some good options as far as getting that default judgment to go away. I'm going to provide you with the number one thing you need to look at. But before I do that, I want to tell you that this episode of the podcast is sponsored by the Consumer Warrior Project. Now, the Consumer Warrior Project is a platform that provides you with the tools you need to represent yourself through a lot of the legal issues related to debt collection. It provides you with the information. The goal of the Consumer Warrior Project in its entirety is to level the playing field. If you're representing yourself in court, if you're going through the bankruptcy process alone, if you're dealing with repossession, wage garnishment, whatever it is, the biggest disadvantage that you have is that you are likely dealing with an attorney on the other side for the debt collector. They are repeat players in this process. They know the rules, they know the procedures. You don't, and they're going to use that to your disadvantage. So, and I have something that's tailored specifically for our topic today, and that's how to vacate a default judgment. You can go over to legal.coach. That's the website, www.legal.coach. And there you'll find the templates, the forms, and the video tutorials that I put together to help you to vacate a default judgment. There's also other things to deal with lawsuits, bankruptcy, debt settlement. So go over there to legal.coach. Check that out. That's all part of the Consumer Warrior Project brand. Okay, so on today's episode of the podcast, I want to talk about default judgments and the number one thing you need to look at to determine if you have any legal leg to stand on when it comes to getting rid of this default judgment. Now, in backing up just a bit, this is how default judgments typically happen, is that there's a lawsuit filed with a court. The creditor, the plaintiff, says that they went out and they tried to serve you with those documents. Usually service entails bringing a copy of the complaint and the summons, or the petition and the summons, and literally putting them in your hand, dropping them off at your house and giving a copy of it to you so that you have a chance to look at the allegations in the complaint and a chance to respond to them. Now, this is where if you don't respond to the complaint and the summons, after a set amount of time, in most states it's 20 days or 30 days, if you don't respond during that period, then the court is permitted to enter judgment against you, and it's called a default judgment. And they usually give them everything that they're asking for, plus interest, plus attorney's fees, and so you end up with these huge default judgments. And just to understand the scope of this problem, there are studies that have been done that show that 90 to 95% of all debt collection lawsuits end in a default judgment. Now, I've done this long enough that I know that there are a number of people that just, stick their head in the sand and ignore it. They're properly served, they don't want to deal with it, and they're just trying to run from the debts, which, as we talk about in the podcast, that is not the way to solve the problem. That will just make things incredibly worse. But there are a huge number of these suits where the service of the lawsuit is not done appropriately. It's not done according to the rules, according to the law. But people end up with a default judgment against them, and then they end up in my office and say, hey, John, you know what? My wages just got garnished, or my bank account just got levied. I didn't even know there was a judgment against me. I wasn't served with the lawsuit. And, this thing is years old, and it's been clipping along, collecting interest over all this time. And so it's a huge problem. And it's kind of difficult to put the genie back in the bottle and to kind of unwind all of this. But let me tell you the one thing you need to look at to determine if you have a case. Because I always tell clients, if they can provide me with this one document, I will tell them in 5 minutes whether we have a chance to get the default judgment set aside and give you a chance to come in and either settle the debt or negotiate it. And that is a document called the Certificate of Service. Sometimes it's called the Affidavit of Service. If you're watching this on the video portion of the podcast, I'm going to show one here on the screen and show you what it looks like. Now, this document, what this is after the process server or the sheriff or the constable or whoever does service of process in your particular jurisdiction, whoever does this, after they serve you with the complaint and the summons, they're then required to provide this affidavit or a certificate of service to the court saying, look, here's what I did. I went by the house and I dropped off the complaint, I dropped off the summons. Here's who I left it with. And then in most cases, they even have to put a physical description of who they left it with. This is very, very important because this is going to give you the one thing that you have to determine if service of process was done correctly. You need to read it very carefully and see who they left it with. Now, in most jurisdictions, they base their rules that govern service off of what's called the Federal Rules of Civil Procedure. And usually it's Rule 4 or right around there. And typically they require that the process server leave the complaint and summons with either the person who's been sued or with someone who lives with the person who's of suitable age and discretion, which generally teenagers will work, even though I don't know if I want my legal standing to be left in the hands of my teenagers, but something like that'll work. What doesn't work is if they leave that with, say, someone's just visiting for dinner, or you just have a friend that happens to be over, or if they leave it with a neighbor. That typically does not work. They usually have to leave it directly with someone who lives in the home or actually is part of the lawsuit. And so you can look at that certificate of service and just tell immediately if they actually did their job correctly. Did they actually come to where you live, your home? Did they leave it with you? Did they leave it with someone else in the house who resides there? It's entirely possible they left it with someone in the house and they didn't tell you about it. They just didn't know what it was. They set it to the side. It gets thrown in the garbage and then you don't respond to it. But there are also a number of situations I see where they don't go to the correct address. They leave it with an old roommate who you don't live with anymore. They leave it with I've even had situations where, and I don't think this is the norm, but I've had situations where process servers just flat out fabricated things. I had a client once who they said that they served her on a specific date and time at her home, and they said they left it with her directly. We were able to go back and look at her Facebook page and prove to the court she was in a different state on that day. She was attending a wedding clear across the country. And so the court was able to unwind that. Something that's always bothered me, like with that particular case, is that the court wasn't as outraged as I thought they might be that this process server had just simply fabricated the situation as far as them actually serving them. But you can look at that certificate of service, and that will tell you if they didn't do it correctly, if they didn't leave it with you or with someone who lives in your home, or if they didn't go to the right address, or if you weren't home at that time and you can prove it, then you may have a legal basis to get the motion or to get the default judgment set aside. And if you do, that's when you go in and you file what's called a motion to vacate that default judgment or a motion to set aside that default judgment. If you're able to do that, then you have to serve that on the other side, and then they'll respond to it, and a court will determine if there's sufficient evidence to overturn that. One other quick thing: in many jurisdictions, if the plaintiff/creditor can't find where it is that you live, they will allow them to do something called alternative service. And so if the court has issued an order saying, well, you don't have to, drop it off in person, but you can mail a copy via certified mail and you can post a copy on the door. Often the process server will file a certificate of service saying they've complied with that order. And they'll say, on this date I mailed a copy to the defendant and I went and posted a copy on the door. If the certificate of service doesn't show that they followed the judge's instructions exactly, then you may have an opportunity to use that to say service wasn't done properly and to get the judgment set aside. So take a look at that certificate of service. This is something I should back up. So you may ask, where do I get this document? If you go down to the courthouse where the judgment was entered against you, this will be in the file. You can ask for a copy of that. Take a look at it. See if they actually did what they're claiming they did. If they did do service and it was done correctly, you're going to have a really difficult time getting that default judgment set aside. Very, very unlikely that you're going to be successful there. But if you get a certificate of service and it's clear that they didn't take the appropriate steps, you have a good case to go in, file the motion to vacate, and get the default judgment set aside. And once they get rid of that default judgment, if they've garnished pay, if they've levied bank accounts, whatever it is they've done, all of that has to come back. It's all unwound. It comes back to the very first step. So again, I have a tutorial on how to do a motion to vacate default judgment. So if you go over to legal.coach, you can check that out there. It's called How to Draft a Motion to Vacate a Default Judgment. And that will show you step by step how to do this. And there's a template in there as far as what you need to provide to the court. But the very first step is going to the court, getting a copy of that certificate of service, and determining if the service was done correctly. So hopefully that helps if you're dealing with a default judgment. Unfortunately, there are hundreds of thousands of people each year that are dealing with these things, and most of them don't even know it's happening. And so this is where you have to go back, kind of piece things together, and find out why it is that they didn't provide you with proper notice. So that's going to do it for this episode of the Consumer Warrior Podcast. Appreciate you listening in, and I will catch you next time.